parties are required to use reasonable steps. This is what the lawyers are required to do under that section of the rule that applies to lawyers, and this is what the prosecutor is being ordered to do under, I think it's 3.8F, and that's what I'm
required. And should we address the range of persons affected by the law, Your Honor? That's really what we're concerned.
The range of persons.
Well, it's our strong belief that the people quoted, and to the extent anyone was actually quoted in these stories, are not people that are in any way connected with the investigation, not people subject to our control, not people subject to whatever types of internal orders we might impose. So will we have the opportunity to address the range of persons?
The range of persons is defined by the rule. I am not expanding the rule, nor contracting it. You are not limited to persons in terms of informing people solely under your control. The rule states that you must exercise reasonable care, this isn't the court's language, to prevent investigators, law enforcement personnel, employees, or other persons assisted or associated with the prosecutor. That is the range, and I will not expand or contract from that range, which is in our rules, and to which you've already agreed on several occasions. You would be bound by. That rule has been held in cases to apply, even when persons are not under the direct supervision of the prosecutor. So the scope of it is persons assisting or associated with.
Your Honor, January 8th, the date for submission by the defense?
January 8th, you want to both have the same date in terms of, or do you want a chance to respond to theirs as well? And
why don't we have an additional waiting to see the defendant's submission and respond on the 15th?
January 8th for defense submission of a new proposed order, 1 through 5 plus, and January 15 for the Commonwealth to respond to its to any comments made on the defense proposal and to any proposed order that it wishes to suggest.
The schedule is fine with us, Your Honor. Thank you.
Now, have you been able to do a pre-trial conference report? Are you ready for that today?
No, Your Honor.
Are you ready to be able to do that today?
Your Honor, I guess if I could, I'd like to update the court on the status of discovery, because I think that's relevant to the pre-trial conference report, and to state some of our concerns with discovery. Back on October 9th, the court set December 6th as the deadline for automatic discovery to be provided by the Commonwealth pursuant to Rule 14. It's now several weeks past that date. There are many things that we don't have which are required by Rule 14. I sent, the defense counsel, Your Honor, sent 1 week ago a letter to Mr. McCauley itemizing 55 items which we don't have and which we need. Our hope, Your Honor, is that we can get a response from the Commonwealth. They'll be willing to give us that material so that we won't need to come to the court and take up the court's time with discovery motions. If we don't get the materials we need in a timely fashion, I do want to alert the court that we will have to file discovery motions to obtain that material. And that material includes, among other things, Your Honor, let me just mention one item. We basically have no forensics in this case yet. In a conference call with the prosecutors on October 8th, they told us we would have forensics, meaning reports and backup material in such fields as ballistics, anything they did with footprints, anything they did with DNA, all of that kind of critical evidence within 30 days. We didn't get it within 30 days. We didn't get it as required by Rule 14, by the deadline for automatic discovery, and we still don't have it. And frankly, Your Honor, there's so much we cannot do on the defense side to prepare for trial, to begin to prepare for trial, until we understand what it is the Commonwealth is alleging in the way of forensic evidence, if anything, so that we can prepare to combat that evidence. So I know the court's interested in moving the case forward. So are we, but we really can't move the case to the next stage, Your Honor, until the discovery we've requested has been completed.
And when is that lecture?
Your Honor, as we've received that material, those have been forwarded. There are outstanding materials which we've been working to get, including all the notes and the photographs and the other related
You
material.
don't have any forensic materials?
Well, the forensic material we do have, but it's been sent. So yes, we have sent forensic materials.
And when do you expect to have this fine to the extent this, normally we would do a final, a pretrial hearing by sort of February, March. It may be difficult to, at which point we would hear all non-evidentiary motions. It would sound like it may be difficult to do that. When do you think that you can get?
Your Honor, it's hard to say. We've told everyone to get us their reports, so we're working on that, and I would hope we'd have that in the next 30 days.
So everything you have that is automatic discovery, you've provided, and you're saying this is
Correct, Your Honor.
Well, for example, Your Honor, I don't know whether they've received any information on jail calls, for example, Mr. Hernandez. Are they listening to Mr. Hernandez's jail calls? Do they have discovery about his jail calls? There's a long litany of things, Your Honor, that we've requested involving, and of course, under the rule, we're entitled to material involving co-defendants,
right.
Statements of co-defendants. Mr. Ortiz, we know, has made a number of statements.
Have you been provided those?
I'm sorry, Your Honor?
Have you been provided with those?
Only the ones that he made initially back in June, Your Honor. We have not been...
And are there no other statements of Mr. Ortiz other than in June?
I've had conversations with Mr. Sultan about additional conversations. So I've apprised him of those, and those are to be reduced to writing.
Do you disagree with the entitlement of any of the 55 on that list?
Yes, Your Honor. There are certain things that are requesting things that we don't have custody and control over, particularly as relates to a matter in Boston. And I said to Mr. Sultan before we start today, I'd like an opportunity to, there's a number of things that we've already provided in that list, and it seems to make sense that we would discuss that further and identify those things that are outstanding, because it is sort of a blanket motion as to many materials, and I know we've provided them thousands of documents, and I presume most of which have would satisfy the requests they're now making.
I don't believe that, Your Honor. They have presented us with thousands of documents, but I don't believe, and I'm happy to provide the court with a copy of the letter the court wants it.
I think it makes more sense for the two of you to meet.
I think it does too, Your Honor.
And go through that list one by one.
That's fine.
1 through 55, see what you may already have been provided, what hasn't been provided but is coming, or what hasn't been provided and is not going to be provided because...
We're ready to do that anytime, Your Honor, and perhaps the
and
court
why not,
wants it.
before you leave today, you set up a date to do
Yes, Your
that. And then if there needs to be a discovery motion, we'll schedule that hopefully at the same time as the pretrial conference. You can do a pretrial conference report. It sounds like it may be premature to try to schedule the filing of non-evidentiary motions.
I think it is, Your Honor, until we're completed with the discovery process, because we really don't know what we're dealing with. But that of course, once discovery is complete, certainly I think setting those dates would be absolutely appropriate. But we're not prepared to do that today. The court would not.
So do you think it makes sense to schedule a hearing on pretrial conference / discovery motions for the first week of February?
Yes, Your Honor. That sounds fine.
Mark, can I see the calendar?
7th would work for all defense counsel, Your Honor.
Fourth or fifth?
That's agreeable, Your Honor.
Do you have any preference for Tuesday or Wednesday?
How about the 5th, Your Honor? Wednesday?
5th at 2:30. If there is to be any filings, a discovery motion, contested discovery motion heard on that date, I would just ask you to file anything by January 29, and any Commonwealth's opposition by February 3rd, so I can review it before the hearing. And if there's anything else that you anticipate being taken up other than the discovery motions filed in that same time frame, other than that, we'll assume we'll try to get a pre-trial conference report executed at that time and schedule, hear any discovery motions and schedule any dates for the filing of non-evidentiary motions and for hearing on non-evidentiary motions.
That's fine, Your Honor. Thank you.
Thank you. Anything else either of you wish to take up today?
No, thank you, ma'am.
Thank you. Thank you very much.
All right, in a pretty lengthy hearing there, wrapping up, we're looking right now at Aaron Hernandez in Fall River Superior Court. You could see him mouthing "I love you" repeatedly to someone inside the courtroom. His fiancée, Cheyenne Jenkins, is in there. Reportedly, some other relatives as well. This hearing lasting about an hour, most of it focusing on a gag order.